May I please, Lordship? My Lord, this is an RSA. Earlier, the appellant filed 2 appeals. Those were dismissed in my favor. I am here respondent. Again, they have filed another RSA, adding some more parties, which were not earlier in their party. So it is urgent matter. It may kindly listed on 22.
RS of which year?
RS of 22. My original case is of 15 years old.
Next week. Then is 28. We'll have it on 27.
27. Oh, like.
Lordship, I beg to mention item number 42, Lordship.
42.
42, Lordship.
Yes.
Lordship, here in this case, the respondent is represented by respondent in person, Lordship. He rang me over telephone that he underwent an operation, gallbladder operation. So he wants any date between
42 is a review application.
review. I am for the review petitioner, Lord.
Sri B. Chakraborty Lanet.
Any date 7, 9 or 8, 7, 8 or 9 November, Lord.
Sri B. Chakraborty Lanet counsel for the applicant has submitted that the respondent, which is represented by the proprietor in person, has some difficulties. As requested based on
7, 8 or 9, any date November, Lord.
November, on 8th of November.
Deeply obliged. And his name may be shown in Lordship on the respondent call.
What is his name?
GD Dhiman, Lord.
We have some issues with whether he can represent. It's not in his person. He is representing a firm. We have some issues. Will not have that. He'll know, you inform him. 811.
Lordship.
811. Oh, just a minute. 811. It's a review of 811. This court may not. Any other date?
I will inform him.
Have you done 16th of November? 16th.
May I please help? But I am paying for listing of an IA in MFA, my lord. IA for combination of bill, my lord. Any date, my lord.
New matter.
Not new, but IA, MFA not numbered, my lord. And
IA notice has been issued.
my lord.
When was notice?
I am, my lord, for respondent, my lord.
Notice was issued when?
But, I have already received, my lord.
When was it issued? What is the date of the order of this?
Exact date not my lord.
Last
Next witness. Yes.
May it please the Lordship. Lordship has filed the IA in an RFA of 2016, Lordship.
IA for?
This is in second appeal because it is to be listed expeditiously, and there are a few
No, IA for what?
for subsequent bringing on record subsequent facts and for expeditious hearing.
Can have it next witness.
May I please, Lordship? Lordship, with the consent of other side, I beg to mention item number 35 for 2 weeks.
35.
35.
Yes.
For 2 weeks, Lordship.
Mr. Ali is not well.
Yes.
It's submitted that the conducting counsel R. Ali is not well. You have taken the consent of the other side. Or please submit to it.
Hello.
35.
May it please the Lordship.
Yes.
Lordship, I beg to mention item number 13, Lordship.
1-3.
Yeah, one still, Lordship.
Yes.
My friend, Lordship, SS Jia, she has some personal difficulty today, Lordship. Would matter may adjourn, Lordship.
Court has been informed that MSSSG has done its counsel for the petition is unable to come to court today. Unable to come to the court today because of some personal difficulty. Sarah, this after a week.
Yes, Lord. Lordship, the interim order is there. Lord.
Sarah, then we insist on Monday next. Interim order passed. Let's continue next set of.
Obliged. Thank you.
May it please the Lordship. Lordship, I would like to mention item number 14, 1-4. Matter may not be taken up to the Lordship as Mr. N. Deka is appearing.
This is a RERA appeal.
Yes, Lordship.
What is the appeal about?
Appeal number.
What is the appeal about? What is the subject matter?
Lordship,
What is the finding on the transformer? What is the finding? Have not read the file. To ask you to come prepared with the facts. At least before any other court. Doubt.
May I please, your lordship? I beg to mention item number 11 of today's list, my lord.
Yes.
I have taken consent of the other side, may be listed after 2 weeks, my.
Yeah, for whom?
I am for the petitioner,
Your name?
R.
Oh,
Chitri.
okay. I'm MSR Chit, Learned Counsel for the petitioner. 22 matter, why did it take time?
Some instructions are required.
Please for some time to receive instructions. For subject after 2 weeks?
Okay.
Is there any interim order?
Interim is there.
Please don't say that. Please on. This on 4th of October. Then interim order passed it. Then send it to the next date of 4th of October. 4th.
May I please, your lordship. Lordship, with the other side counsel, my lord, I beg to mention item number 34, my lord, 2 weeks time,
34.
34.
You are for whom?
Y Ali, a petitioner, my lord.
On a prayer made on behalf of the appellant. Just after 2 weeks. Item 34.
Tyler.
Yes,
May I
ma'am.
please, your lordship? Lordship, I beg to mention for listing lordship, it's a MSCT case. MSCT case 283, 2020 lordship, it's all pending matter. Notice
You are
was
for
issued
whom?
lordship,
You are for whom?
petitioner lordship.
Petitioner in a not petitioner. You either can you be an appellant or the
Yes, lordship.
appellant?
Yes, yes.
For enhancement or what?
Yes, lordship.
The appeal is for enhancement or you are for the insurance company?
Uh,
Who has filed the appeal? Appeal has been filed by whom? Insurance company.
Yes, lordship.
You are for the insurance company.
No, no,
Then
not, it's a assurance company limited lordship.
that is it. The insurance company has filed the appeal.
Yes, lordship.
You are for the appellant.
Yes, lordship.
What is the stage?
Notice was issued lordship.
Notice. Appeal has not been admitted.
Yes, lordship.
You know the minimum things what has happened. What notice is issued in an appeal? Appeal of which year?
2020 lordship.
Next. Okay. Yes, next.
Is your lordship? I
Give
beg,
the next Friday's date, not this Friday.
is your lordship? I beg to mention one item for listing lordship. This is TRP IO. It was filed on 18th 9, 2023.
New
Mm.
matter.
Yes,
Yes,
lordship.
new matter we can fight. Day after tomorrow. Yes, but
may I please, your lordship? So lordship, I beg to mention one listing for FAO 29 of 2023. Lordship, it's in the stage of admission.
when was it last listed?
Last listed on 7/8/23.
Returnable on. When was the next date fixed?
On Friday, your lordship.
When was the next date fixed in the earlier order?
Earlier order, it was picked on
You need to know, not now, not now. Mention again tomorrow, come prepared. Yes. Yes,
May I please tell you, Lordship 439 bail application, Lordship earlier rejected by this marble court, Lordship. Lordship, appellant petitioner is arrested on Lordship 23/8/2021. If
NDPS.
Lordship only 2 witness examined, Lordship kindly have a look at page 29.
Let us see the earlier rejection order.
Lordship earlier rejection order was not annexed. Lordship that was not annexed, only because statement was made. Order was
You're not supposed to annex the earlier order.
Lordship, earlier order of the Sonabul court was not annexed. Only lower court order was there. And that is at annexed Lordship C.
This is not the way to how you file a petition.
Lordship, they have not annexed.
Annex it. Let us see the reasons which we have cited while rejecting. Sri L.R. Mazumdar, Learned Counsel for the petitioner. No, this is an application under Section 439 of the CRP in connection with issuance of case. It appears that this application that on an earlier occasion, this court had rejected the prayer for bail. This court has rejected, however, the order of such rejection has not been annexed. Learned Counsel L.R. Mazumdar prays for a week's time to produce earlier order. Please, on Monday next.
Alright.
You put it on record, don't just place it. Put it on record, file a short of it. Yes, please.
May it please your lordship. My lord,
We'll have these matters for final disposal, 2, 3, and 4.
yes,
We'll have it after the motion. How many admissions are there? We'll have it after the motion and
lordship,
after item number 9.
lordship. After my
3 and 4 also. Top of the list matters immediately after item number 9.
May it please your lordship.
Third portion.
Lordship, this is a transfer petition for transferring an appeal, your lordship. Lordship knows the valuation of the district judge, honorable district judge was changed, your lordship. This appeal was filed when honorable district judge had the valuation to try this appeal, but however, it was subsequently changed and the appeal is pending there, your lordship. As on date, your lordship, after the amendment, honorable district judge does not have the jurisdiction to try this appeal, so it may be transferred to this honorable court.
You can file it, an application on the administrative side.
That could be done, but we could not file an application before the honorable district judge because it will have to be withdrawn and
No,
the
you
court.
can file an application on the administrative side of this court.
We can do that as well.
Do that. So judicial intervention is not necessary. We'll keep this pending. Third, Sri B. J. Mukherjee, Learned Counsel for the petitioner who has filed this application under section 24 of the CPC, praying for transfer, public withdrawal of title appeal number 10 of 2021, pending court of the Honorable District Judge Kokrajhar to this court. It is submitted that due to change in the territorial jurisdiction,
Pecuniary.
pecuniary jurisdiction, by wide notification dated,
By the Assam Agra.
by the amendment
Amendment.
to the Bengal, Assam, Bengal Agra and
Agra and Assam.
Assam Civil Code, within bracket Assam Amendment, bracket close, Act of 2020, comma, it would be at the jurisdiction would lie in this court. This court is of the opinion that instead of passing a judicial order, comma, the petitioner can approach this court on the administrative side for appropriate orders. Let, in view of that, matter is adjourned by 2 weeks. If at all we are required to pass orders in the judicial side, yes, what is the
May I please, my lord? This is the transfer petition, my lord.
Hmm.
My lord, petitioner's husband, my lord, file a title suit, my lord, for dissolution of the marriage, my lord.
who has filed?
Petitioner's husband, my lord.
You're the wife.
I am the wife, my lord. At the Hosai, my
Petitioner
lord,
is
however,
the wife. Husband filed what?
my lord, title suit, my lord.
Title suit for?
For dissolution of marriage, my lord, under Hindu Marriage Act, my lord.
Yes, under HMA. Yes, then
My lord, the petitioner's file is written statement, my lord. However, due to her inconvenience, my lord, and safety issue, my lord, she is the only daughter of her father, my lord. Due to that, my lord, petitioner want to transfer,
where is the suit instituted?
my lord.
Where is the suit instituted? Which place?
My lord, lordship may come to
Which place? Which court?
my lord, is at the Hosai, district Hosai, my lord. I want to transfer to the Morigaon, my lord.
It is before the district judge
Yes, my lord, district judge.
or additional district judge.
Additional district judge, Hosai.
You have to name the court. You are not been equipped.
My lord, additional district judge, Hosai, Shankardev Nagar, Hosai, my lord.
Additional district judge. Ujay.
Shankardev.
Where do you want?
I want to transfer, my lord, Morigaon, my lord.
What are your grounds?
My lord, petitioner being a lady, my lord, it is inconvenient for her, and she is the only daughter, my lord, of her parents, my lord. She is staying along with her parents at the Zagirot,
After
my
the
lord.
marriage, you would have stayed with your parental with your
My lord,
parents.
My lord, what happened, my lord, after the
Only
marriage, my lord,
only daughter will make any sense.
my lord, after the marriage, my lord, there is a dispute between the, as my lord, present respondent, my lord, claiming my dowry, my lord. That's why, my lord, she could not stay along with her husband, my lord. She come back to his parents' house. My
That
lord.
is a different matter. But
Yes, my lord. If
how
my
can you say that you are the only daughter? After your marriage, you are not supposed to stay at your parental home. You have to stay at the
lord,
matrimonial home.
it's true, my lord, but presently, my lord, petitioner is inconvenient, my lord, to go from the Zagirot to my lord, Hosai, my lord. In my lord,
How far is from Jagirot to Ujjain?
lord, it's more than 100 kilometers.
100 kilometers.
I have no, it's far, far. It's more to be 90 kilometers, my lord. In lordship,
Not too far off.
my lord, in the earlier question,
Where was the marriage solemnized?
there is the petitioner's home, my lord,
Where?
Zagirot, my lord. My lord, in earlier occasion also, my lord, petitioner's husband filed a title suit for the judicial separation, my lord. And the, on finding that, my lord, this present petitioner approached before this honorable court, and honorable court ordered this honorable court allow her prayer, my lord, and transfer the said case from Hosai to Morigaon, my lord. But however, my lord, the present respondent, my lord, would do that petition, my lord. In lordship, I annex this order, my lord. This order is on page 12, my lord.
Okay. Your KM Hassan,
Yes, my lord.
Archbishop KM Hassan, Learned Counsel for the petition, who has filed his petition under section 24 of the CPC, praying for transfer of title suit within bracket D, number 82 of 2022, instituted by the respondent at before the Learned Court of Additional District Judge, Hojai, Shankardev Nagar. Full stop. The suit is for dissolution of marriage. Full stop. Sarah. The Learned Council has submitted that even on an earlier occasion, the respondent had initiated a proceeding for judicial separation,
Right.
which at Hojai, and in that proceeding also, this court had passed an order of transfer
Right.
to the district court at Morigaon. However, the state suit was withdrawn and thereafter the present suit has been instituted. It is also submitted that the petitioner, being a lady, would face inconvenience to attend the case at Bhojai, and the marriage was also solemnized at Jagi Road within the Jagi Road in the district of Mori. Issue note returnable on on 13th of October.
My lord, till then, my lord,
That step be taken for service of notice upon the respondent by registered post court of Para. The learned counsel has paid for an interim order. What is the stage?
my lord, I filed WS.
Then now
Now we are presently for evidence. Evidence, ma'am.
taking into consideration the facts and circumstances, it is directed that till the next date fixed, further proceeding in at TSD 8/2022 pending before the National District Judge Bhojai shall remain suspended. The last line, since this order is inexecutive, the respondent may come up. From a proceeding, it pays for transfer of case from the unit to the appropriate court at Mori.
Obliged.
Yes, what is this?
My lord, here I have challenged the order at page 18. Whatever in this case, the petitioner before your lordship, they are the judgment debtor of an execution proceeding.
Petitioner is the judgment debtor.
And the
Suit
respondent, decree holder,
Suit for
my lord,
suit for
title and rest of cash property, possession. The execution proceeding was instituted in 2014. In 17, it was dismissed for default.
which one? You are the judgment debtor.
I am the judgment debtor. The
Uh,
decree holder instituted the execution proceeding in 2014.
degree of which year?
Decree of 99.
Okay.
Decree of 99. First appellate court confirmed in 2001. The High Court in RSA 2012 be dismissed. So, your lordship, at the first point, kindly peruse page 18. This is the order. I have in
No,
There-
that doesn't matter. In 14, they had executed, they had
2014 execution was instituted. 17, it was dismissed. Dismissal order, your lordship will find at page 99. Kindly
17
peruse
dismissed for default.
default. After 17, page 99, for a moment, kindly.
99.
Page 99, this is the order of dismissal. My lord, got it. Both sides represented, seen petition number such and such filed by JD.
Yes.
Wherein has prayed to dismiss the case as decree holder has failed to take step. Peruse, the decree holder has not taken step for any, nor any submission for default is advanced.
Yes.
Hence, the case is dismissed for default.
Hmm.
My lord, kindly note the date.
Hmm.
6/7/17.
Yes.
Thereafter, my lord, after 5 years, in 2022, page 103, this application was filed on 18/6/22.
Page
103.
Yes.
My lord, kindly note that it was filed under Order 21 Rule 1061, read with 151. we have filed our written objections. Yeah, Lordship kindly come to the page 106, the ground one.
106.
6, ground for restoration.
Yes.
In fact, it is start 105, madam. Kindly turn to the page 105. That suddenly, I am reading from page 105.
Yes.
Ground 1. That suddenly on 33/17, the decree holder Anil Bora suffered from lower respiratory problem and was admitted to JNRC hospital due to serious conditions. So he was under treatment of JNRC doctor in long period. Advocacy statement, my lord, no time period, etc., nothing mentioned. The petitioner Anil Bora, being the eldest brother of other petitioner, had dealt with the case. So the other petitioners have no communication with the learned advocate. Moreover, the other petitioner were busy with the patient. So there was no communication with the advocate for taking step. The judgment debtor, by taking the advantage, filed a petition bearing number such and such for dismiss the execution petition, and the honorable court has allowed the same. Medical certificate has been enacted. The petitioner Anil Bora is still undergoing treatment because he has not completely cured from his disease. That due to the above mentioned cause, the petitioner were not mentally stable till last 10 days to file the instant petition. After 5 years, they said, my lord, they are so last 10 days. That this application is bona fide. So these are the basic ground, my lord. And we have raised our objection, page 108.
108.
110.
Objection.
Objection. That no order under 21 Rule 105 Sub-Rule 2 was passed by this honorable court, and also no order under 21 Rule 23 Sub-Rule 1 was passed by this court. So this petition under 106 relating to above mentioned rule only for dismissal execution proceeding.
Yes.
That order dated 6/7/17 is an order of dismissal for execution proceeding. In order 21, there is no provision for restoration of execution proceeding when dismissed for default. So also in the whole CPC, there is no provision for restoration of execution when dismissed for default. That the petition is hopelessly barred by limitation. Any petition for restoration limitation is 30 days under Limitation Act. That aberment made in the petition are there.
Then what is that?
Then the imping order passed, ignoring this, all this, page 18.
Page
18, 1/8.
1/8. Yes.
Both sides are duly represented. By this order, this court is going to dispose of MJ case number such and such filed under order 21 Rule 106 Sub-Rule 1, read with section 151 of CPC, praying for restoration of the title execution number such and such, which was dismissed for default by order dated 6/7/17 of the petitioner decree holder side. The petitioner decree holder side have prayed for setting aside the order dated 6/7/17. The petitioner side has contended that the petitioner side filed petition under order 21 Rule 11 CPC for execution of decree in connection with title to such and such, according to the title execution case number such and such was registered. During the time of execution,
We have read. Heard AI within council for the petitioners who have filed this petition under Article 27 of the Constitution of India being aggrieved by an order dated 12/7/2023 passed by the learned Munsif number 1, Murigaon, in mid-J case number 85 of 2022, arising out of title execution case number 3 of 2014. Para. The petitioner is the judgment debtor of a suit for declaration of right and restitution and restoration of possession, in which decree was passed in the year 1999. However, there were appeals, including one before this High Court, which was disposed of on 2012. Thereafter, in the year 2014, the aforesaid title execution case number 3 of 2014 was instituted. The state application was, however, dismissed for default for want of taking steps on 6/7/2017. It's the case of the petitioner that long thereafter, on 18/6/2022, the respondent had filed a petition under Order 21, Rule 106 within bracket 1, read with Section 151 of the CPC, for setting aside the order of dismissal dated 6/7/2007. The state petition was objected to by the petitioners by filing written objection. However, by the impugned order dated 12/7/2020, the petition has been allowed and the execution case has been restored to file. The learned counsel for the petitioners has submitted that the relevant factors, namely, including the issue of maintainability of the petition, as well as the point of limitation, were not been considered by the learned court. That notice be issued returnable by 6 weeks. That steps be taken for service of notice upon the respondent by registered post. Step by tomorrow, be put in the learned counsel for petitioner, pray for an interim order. After perusal of the facts and circumstances, this court is of the opinion that a prima facie case is made out, and if the impugned order is not paid, there may be irreparable loss in it. The balance of convenience is also in favor of the petition. In view of the above, till the returnable date, further proceeding in title execution case number
03 of
2014 in the court of the learned Munsif number 1, Murigaon, shall remain suspended.
I am obliged. Or 2 days time may be given. For
By
step.
tomorrow,
Volume mass, my lord, people,
you will not photocopy, it, somebody else will photocopy.
hang on.
Oh, I thought it last time, expert modification.
May I please?
Yes.
My lord, this petition has been
Item
filed
number?
against an order passed by the learned Munsif number 3, Dhuri, page 30 and 31, your lordship. By this order, my lord, the learned trial court has rejected the WS filed by the petitioner. There is only 11 days delay in filing WS, my lord.
Why are you taking 11? Where is the delay?
My lord, the petitioner number 1,
What is the time prescribed for filing WS?
90 days, your lord.
90 days.
90 days,
Is it 90 days?
my lord.
It's not 90 days. 30 days. 90 days is the extended time.
Yes.
Time is 30 days. You-
After 90 days,
Is it
11
you
days.
say
delay.
simply say 90 days? Where is 90 days? Let us see.
In
90
the-
days is the extended time. Now why couldn't you file within the extended time?
Lord, the petitioner number 1, she is the mother of petitioner number 2 and 3, my lord. She is as a person, my lord, she is suffering from some ailment. And the petitioner number 2 and 3 are busy with the petitioner number 1, my lord.
Busy.
For treatment, for the
What
purpose of
treatment?
treatment, my lord. Not only 11 days delay after
What
90
treatment?
days.
What treatment?
Some ailment, my lord.
What ailment? Tell us.
As a person, my lord.
Is it 67 years? 67 is aged.
But physically very weak, your lord.
What weakness? Tell us. What is the ailment?
And in collecting some relevant documents also, my lord. But only 11 days, my lord, and
What is the suit for?
for specific performance of contract, your lord.
Specific performance of contract.
My lord.
What is the contract?
Contract was, my lord, in regard to a plot of land. As per the plaintiff purchased the suit land from the father of the petitioner number 2 and 3, your lord.
What is your name, Rahman?
Yes, your lord.
Mr. Rahman, it's not matter of 11 days or 100 days. It's a matter, even one day may be fatal. There are no plausible explanations. We understand that it's not mandatory, it is directly, but in every case, if you delay,
For condemnation of such delay, my lord, one separate petition was filed. And that is not
under what provision?
under section 5 of the limitation act.
Section 5 will lie for delay condemnation in filing a WS. What is section 5? Let us see what is section 5. Section 5 lies for what?
Condemnation of delay, your lord.
Of what? Will section 5 lie in a suit? Why doesn't it lie in a suit? What is the expression used in section 5? Let us see section 5. Should come prepared. Repetition. The expression is appeals and application.
Right.
Read properly. Don't just hurry up to court. Or what is the stage?
That is this evidence here.
When was the rejection?
My lord, it is shows, my lord,
When was the rejection of your prayer
Third-
for filing WS?
page 31, your lordship.
3-1.
31, 28/6/2027 is next date, your lordship. And the plaintiff was directed to take some step, your lordship. Not evidence, your lordship. It is for steps, your lordship. Initially,
Grounds of illness cited by the defendant is not supported by any document.
Hmm.
We cannot find fault with this kind of orders. Or P.K. Roman learned counsel for the petitioners who have filed this application under Article 227 of the Constitution of India against an order dated 21/6/2023 passed by the learned Munsif number 3, Dhubri, entitled to number 178 of 2022, by which the prayer for filing statement after the prescribed period has been rejected. Full stop. The petitioners are the defendants in the aforesaid suit. Full stop. The learned counsel has submitted that the written statement could not be filed within the extended period of 90 days due to certain factors which were beyond the control. Full stop. It is specifically averred that the petitioner number 1 was suffering from various ailments. Full stop. To emphasize, this court does not find any fault with the reasoning assigned by learned Munsif number 3, learned court below, while rejecting the application, for the interest of justice, one opportunity may perhaps be granted. That notice be issued, returnable on 9th of October 2023. That steps be taken for service of notice upon the respondent by registered postage steps by tomorrow. The learned counsel for the petitioner prays for an interim order for prepare, considering facts and circumstances, and in the interest of justice, it direct that till the next date fixed, further proceeding in. You want to see of the order?
Order, yes.
What will you gain?
My lord.
We stay the order, okay, then what do you gain? You should know how to structure your
Well,
prayer at least.
Sorry, my lord.
What sorry?
Further proceeding maybe.
Where have you stated?
Well.
We cannot frame your prayers.
Sorry, my.
Don't they have this habit of filing the petitions in a mechanical manner without any application of mind? Further proceeding entitled to number 178 of 2020 in the court of the learned Munsif number 3 to be shall remain suspended since this order is passed on expert court. It is further observed that taking into account the issue involved, an endeavor would be made to dispose of the petition on the appeal of the contestant.
Matablas. Hello. The impugn order is my lord. Page 55, my lord. Impugn order is page 55, my lord.
What is the matter?
My lord, actually, in this case, I have filed a suit for specific performance of contract.
You are the plaintiff.
I am the plaintiff.
Just a minute.
Thereafter, defendant has
Just,
filed
just a
my
minute.
lord,
Petitioners, how many petitioners are there?
two petitions.
Petitioners are plaintiff.
Yes,
Suit for specific performance.
specific for contract.
Okay.
So against that, defendant had filed written statement from counterclaim. Defendants number 1 and 3.
Yes.
A written statement come counterclaim
1 and 3.
1 and 3. And then we have filed, the plaintiff has filed WS against counterclaim also.
WS filed by you.
WS filed against counterclaim. So one of the thing taken by the defendant is that we have not paid rupees 5 lakhs in cash to them, because according to Income Tax Act, we are not allowed to pay rupees 5 lakhs in cash. So they denied the receipt of rupees 5 lakhs. Against that, we are stating our WS that we have paid rupees 5 lakhs, and that has been reflected in our income tax returns also. That has been reflected in our income tax records also. We said that is in recorded in the income tax records. So that has been filed by us. So now, at the time of filing plaint and WS, actually at the time of filing WS, our tax practices were not there. So at that time we could not file the income tax return. But after 2 or 2 days, we came back and we filed an application for allowing us to submit our income tax return along with copy we have supplied it. So in this way, the income tax returns are very relevant for the purpose of the case. Because
Did you make the averment in the WS
yes, the WS
regarding ITR?
Yes,
You had made,
you have made, yeah,
but the document was not annexed.
document was not made.
Okay.
The amendment was made. So we filed the petition. Perhaps the learned trial court overlooked it and said that it is not in pleadings. That
That is exactly what we'd like to see. But let us see your WS.
yes, ma'am.
Which page?
My lord. In their counterclaim, my lord, in counterclaim para 24,
Page.
running page, my lord, running page is 33.
33.
33.
No, we want to see your WS
My WS,
against the counterclaim.
my lord. In my WS against counterclaim, my lord, it is in WS starts from page 41 and relevant person is at page 42.
Just a minute. Just page 40.
42. 42.
WS starts at which page?
Page 41. And relevant pleadings are in page number 42.
Yes, which part? Which paragraph? 42.
Since
Where we
11th line. Since 11th line.
Yes.
The entire amount of which 5 lakhs was paid at the time of execution of agreement, and it had been shown in the income tax files of the plaintiff. Thus the
Where?
my lord.
Page 42.
Page 42, my lord.
Yes. Which line?
11th line.
From the top.
11th line.
From the top.
From the top.
The entire amount.
And the entire amount of
Yes.
which 5 lakhs only was paid at the time of execution of agreement, and it had been shown in income tax file of the plaintiff.
Okay. Now where is your application?
The application is my lord.
Let us see the rejection order.
My lord.
Is it page 56?
Page 47. Our petition.
Isn't it 4/8/2023?
Oh, petition annexure number
No, not
4.
petition. We want to see the order. Impugned order. 55, isn't it?
Impugned order, my lord.
55.
Yes, 55. It starts from 55, and relevant part, my lord, we can see at page 56, last para.
4/8.
Yes.
You filed under order 7/14/3. Okay.
My lord, the relevant part is only last para.
heard under concept of defendant under concept of charge. I have perused the contents of the plaint. Last para. I have perused the contents of plaint, and on such perusal, I find that plaint contains no plea whatsoever regarding filing of income tax return of the plaintiffs for any assessment year.
Okay.
The additional documents thought to be filed by plaintiff are beyond their pleading, as such petition is rejected. So, my lord, pleadings does not mean plaint only. Pleadings include plaint and WS. Madam. Order 6 rule 1 manner. So, pleadings contains this.
Now, did you meet the requirement of order 7 rule 43?
My
You
lord.
say, you ask for leave of the court.
Leave of the court, my lord.
As Learned concept for the petitioner have filed this present petition under Article 227 of the Constitution of India, being aggrieved against an order, been aggrieved by an order date 4/8/2020 passed by the learned civil judge number 3, Kamrup within bracket M, on petition number 4363 of 2020, which was filed under order 7, rule 14 within bracket 3 of the CPC. The petitioners are the plaintiffs who had instituted the connected suit, being title suit number
141 oblique 22.
141 of 2022
2021.
for specific performance of contract. Full stop. The defendant numbers 1 and 3 had filed written statement and also a counterclaim. Full stop. The aforesaid counterclaim was responded to by the petitioners by filing a written statement. Full stop. Para. By drawing the attention of the said written statement, comma, Sri Sharma, the learned counsel for petitioners, has submitted that on the issue of payment of rupees 5 lakh, comma, there was a specific averment in the said written statement with reference to the income tax returns. Full stop. However, comma, since the returns could not be filed along with the written statement due to certain reasons, comma, the application under order 7, rule 14 within bracket 3 of the CPC was filed on 4/8/2023. Full stop. Para. The learned, no, put it on. Oh, put it on. Statement was filed. However, comma, the learned civil judge, senior division number 3, by the impugned order dated 4/8/2020, had rejected the said prayer by holding that there were no pleadings to support the aforesaid prayer. Para. Sri Sharma, the learned counsel, submit that such observation is apparently erroneous, as averments in the written statement was overlooked. Full stop. Para. That notice be issued, returnable by 4 weeks. That step to be taken for service of notice upon the respondents by registered post with 80 steps by tomorrow. Sarah, Sri Sharma, the Learned Council prays for an interim order. Also, after considering the facts and circumstances and being perhaps satisfied that the order has overlooked the relevant reading in the written statement from this direct that till the returnable date, further process in latitude number 144 of 2022, pending the court of the Learned Civil Judge number 6, Kamprov Dam shall remain suspended. Subject to expert may come for. Steps by tomorrow.
Well, definitely.
May please, your lordship.
Nine. 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 We'll have it after 90. Finish up the admission. I hardly have 4-5 matters.
Council ME Mondal is like another court, my lord. Letter we pass over for that day.
Yes, Mr. Dutt.
Amendment was disallowed on technical ground. Subsequently, it was allowed. He wants to say, the petitioner wants to say that is barred by his. It will not be barred by his. Because the earlier one was rejected.
You had filed an amendment application that was
Yes.
initially
Yes.
dismissed because of technical reasons,
Yes.
subsequently allowed.
Yes.
Now the question of limitation has been raised by them that it was barred by limit.
Barred by res judicata.
Res judicata.
Res judicata. Res judicata will not be allowed, will not be applicable. Because the earlier one was not decided on merit.
Let us see the earlier order.
Earlier order.
What about constructive res judicata? Now, was liberty granted to you?
Yes, yes,
Liberty was granted.
yes, yes.
Let us see the earlier order of
Page 36.
Page 36. It was rejected on technical ground. Page 36.
where is the liberty?
No
Liberty was not there. But
Liberty was not.
proposed amendment is not clear in itself due to lack of detail. In view of the observation and reasons, I do not fit.
I am not.
Subsequent order is at page 43.
Where is the subsequent order of allowing?
Page 43.
Page 43.
The earlier order has been put at page 45. Your lordship, please to see at page 46. From the above, it to ecstasy appear.
Yes, sir. Who is the second? Control. Would like to hear him.
After some time, madam, because I have come for this case already.
After some. For second half, we have to rise early. There is a meeting today.
Oh.
By around 3 o'clock. But we'll try to have your man. Video conference.
My lord, with the consent of other side, my lord, I am seeking adjournment, my lord. Kindly fix any other day.
Mr. Purkas, what is the matter?
Matter, my lord, the suit for specific performance of contract, my lord. And the
You are agreed by what?
agreed by my MJ case was dismissed on the ground of limitation.
NJ case.
MJ,
You are the tenant.
I am the plaintiff, my lord.
Tenant.
Yes, ma'am. I am not the tenant. I am not the tenant.
Agreement, according to him, there
There
was
was
an agreement. And in terms of the agreement, my lord,
If he is seeking adjournment, we'll have it after 2 weeks. After 2 weeks, is it okay?
yes.
On the prayer of Sri H.R. Chaudhary. No, Sri H.R. Chaudhary led counsel for the petition placed for adjournment. Also heard A.K. Prakash, current counsel for respondents. Just after 2 weeks.
Interim order is there.
So in that case, we'll fix the date. This on 4th of October,
Lordship, better, my lord, fix the matter on 5th of October.
Thursday.
5th.
5th of October. Sarah, 5th of October will take off for disposal.
Yes.
Interim order passed at date.
Obliged.
Yes.
Regular first appeal, my lord.
First time.
First time, my lord. In fact, my lord, it was, my lord, initially registered as a RSA, my lord, by the office, my lord. So,
Why
my lord,
arrested? Why?
initially, my lord. Yeah, my lord, yeah. Therefore, my lord, we had to file again. We had to take down, my lord, to take back the file and refile it. My lord.
It's a regular appeal.
It's a regular appeal, my lord. It
Madam,
was-
you are for whom?
I'm appealing for the sole respondent.
Before notice,
No,
or there was a
on that
condemnation?
delay condemnation petition. we
Zero
were-
condemnation. Okay. Heard we are the Senate counsel for the appellant. Appellant who have referred the present appeal against a judgment and decree dated 23/12/2021 passed by the learned civil judge, Dibrugarh, entitled suit number 20 of 2012, whereby the suit has been decreed in favor of the plaintiff and the counterclaim of the present appellant, who are defendant numbers 1 and has been dismissed. Admit there are call for the record. You are accepting for all, madam?
Sole
Yes, only
respondent.
one respondent is there.
Your name?
Miss B Devi, Lord.
MSB Devi, Learned Council has already entered a bid on behalf of sole respondent and therefore accept notice. Also, that an extra copy of the memo will be served upon her by
I've already
tomorrow.
served me.
Okay.
The
List
I-
of the 6 along with report on receipt of LCS.
my lord, there is a IA, my lord, for
I4
for stay of the execution, my lord. They have already filed an execution proceeding. Title execution 1 of 22, my lord.
3RD Learned Council for the applicant as who by means of this app has paid for 3 years of the title execution is number 1 of 2020 arising out of judgment at the dated 23/12/2021 passed by the Learned Civil Judge Dibrugarh entitled footnote 20 of 2012 of the connected appeal being RFA 26 of 2020 has been admitted to the court of Sarah. The Learned Council for the applicant submit that if the execution is not paid, common, the entire appeal would be rendered infructuous. Also heard be the Learned Council for opposite party court of Sarah. Sarah court has been fructuous. However, if further sub that there are good grounds of appeal which is likely to succeed as possible. Considering the aforesaid factors, it is direct that pending disposal of RFA 26 of 2020, the title execution number 20 of 2020 shall remain suspended. I according to disposal of
But in this case, my lord, may I pray on behalf of Mrs. NS Thakuria, my lord. My lord, the matter may kindly be taken up next Monday.
next month on a prayer made on behalf of MS and its council appellant, just on Monday.
Obliged.
Yes.
Yes, Your Lordship. Your Lordship, this MFA is filed against the order dated, judgment dated 12/6/2023, Your Lordship. That is a page
By the radio transcribe,
railway, Your Lordship.
what is that?
Your Lordship, the husband of the petitioner died in accident, Your Lordship, in the train coach, Your Lordship, in the toilet of the railway coach, Your Lordship, while traveling from Guwahati to Delhi, Your Lordship.
Your claim has been dismissed.
Yes, Your Lordship.
What's your name?
I.H. Laskar, Your Lordship.
I heard Learned Council for the appellant who have preferred this app under section. What is the judgment date?
Your Lordship, page 14, Your Lordship.
Under section 23 of the Railway Claim Tribunal Act 1987 against the judgment and order dated 12/6
12/6/2023.
passed by Learned Railway Claim Tribunal, Guwahati in our some side of that. By the effort that
PS,
the claim has been dismissed.
Dismissed.
admit, call for the record. PS law for learned CGC accept note on behalf of that extra copy of memo will be served upon by list of the secretary along with report on healthcare.
High level. Okay. Also, this is a matter of enhancement, appeal for enhancement of compensation on the MSCT Act.
How much is the award?
1,24,919. It is a minor,
How much is your claim?
almost 10 lakhs.
Injury case.
Injury case.
He got to counsel for petitioner for the appellant who by means of the petition preferred under section 170 of the Motor Vehicles Act 1988 has sought enhancement of the award granted by judgment and order dated
5/7/22.
5/7/2020 by the learned M is number 2 compromise in M is number 227 of 2030. So para call for the record that steps to be taken before service of notice on the respondent by usual process as well as by registered post steps within 2 days. Para along with report on service as well as on LC.
This is an statutory appeal lordship under
Part 3 is the section and account for the appellant insurance company which has preferred present appeal under section 170 of the Motor Vehicles Act 1988 challenging a judgment and award dated 21/6/2023 passed by the learned MPC additional district judge within bracket FE Dibrugarh in MSC number MSC case number 53 of 2015. Para admit para call for the record. That
the state petition is there, Lord.
how much is there?
13,62,000.
Part 3 is the section. Learned counsel for the applicant who by means of this application has paid for stay of the judgment and award dated for the Dibrugarh. The
We are here,
connected appeal has been admitted to the court of para. The learned counsel submit that there are good grounds of appeal to reflect acted. At the same time, the objective of the legislation cannot overlook. In view, have you deposited anything?
but your only statutory deposit will have deposited.
In view of the above, it is directed that the impugned judgment and award is passed by influence, not that shall remain is subject payment of 50%.
50% of our liability, Lordship. Two vehicles are involved, 50/50 is given, Lordship. after 13 lakhs 62,200, we are liable to
50%
50%.
of the amount which has been directly paid by the present appellant in the registry of this court. I got the line. Please take care. The Senate Council clarified that since 2 vehicles were involved, the amount has been directed to be deposited.
Lordship, 3 vehicles are involved actually, but only 2 are held liable. Lordship.
Since, submit that by the impugned award, the liability has been settled equally between two vehicles, and the present appellant is the insurance company of one of the vehicles. Mr. Das, your counter, your colleague has come. Mondal has come or not? No, don't disturb him. Has Mr. Mondal come? No. Wait for a while then. Wait for a while. Ask Mondal to come. Okay.
May pleasure, Lordship. My lord, this is an appeal filed by the insurance company, Lordship, against the judgment passed by the Workmen's Compensation Commission of Workmen's Compensation, Nagaon. The substantial question of law, Lordship will find order dated 7/1/11.
Okay. Two questions.
Two substantial question of law, Lordship. One is that whether the wages of an employee, that workman, is included the daily allowance or not, Lordship. That question of law is already settled by this honorable court as well as honorable Supreme Court, Lordship. This is not included, Lordship.
Wages does not include
Yes, Lordship.
daily allowance.
Yes, Lord. Earlier, our High Court division bench judgment is there, Lordship.
Yes.
Reported in 2006 3 GLT 870, Lordship.
2006.
3 GLT 870.
870.
That is in paragraph 12.
What is the name of? What's the name of?
Parties' names are Oriental Insurance Company Limited versus Lakshmi Das and others. After that, Lordship, one judgment of the Honorable Supreme Court, 2011 1 SCC, where it is held that it is not, it is included, Lordship.
later decision by this
Yes,
court.
yes, by, no, by Honorable Supreme Court 2011, 1 SCC 304. This is stated that Lordship, Honorable Supreme Court held that it is included, Lordship. But again, Honorable Supreme Court in the year 2017 held that it is not included. So latest is this 2017-15 SCC 579.
Who is for the other side?
Lordship, no one has appeared, Lordship. And on the basis of this judgment, Lordship, our
What
High
was-
Court,
What was the intervening judgment where it was had to be included? 2011 one is
yes, where it is included, 2011, 1 SCC 304. I may, like, paragraph 7.
that decision has been taken care of in the later decision.
Yes, Lordship. And our High Court on this latest decision, Lordship, judgment was passed by order dated 3/9/2019, MFA 19 of 2010. Considering the latest decision of Surekha,
Madam, you have said that Surekha, Amiruddin has been considered. Where is it? Amiruddin has not been considered.
yes,
And Amiruddin is also by a two judges bench.
Yes.
Surekha is also by
it
two
is
judges.
two.
I think we have to go by a beneficial legislation. How much difference will it make? Daily allowance.
Daily allowance 80 rupees is there, Lord,
How much difference?
and 1500.
That case.
1500.
Oh, it's an injury,
It's an injury case, Lord.
permanent disablement.
No, actually, that is not there, Lordship.
No,
Doctor,
that is the second question of Robert
yes,
side.
that is,
But
yes.
he claimed to have suffered permanent disability.
Yes, Lordship. And
What is the nature he had claimed?
nature, loss of earning 40% assessed, Lordship, and
And what is the
disability.
nature?
Nature is a permanent, they are saying.
What disablement?
And the injury is, Lordship, this chest and this
Wrist.
wrist, left wrist injury.
It
and-
affected his earning capacity as per him.
But Lordship, there is
As per him.
As per him. That
What you
for-
say?
But Lordship, as per he has treated in the Nagaon hospital, where it is nowhere he has stated he has sustained any permanent disablement, Lordship. He has gone to a doctor, subsequently has gone to a doctor where in the Nagaon, he stayed for 4 days, Lordship. There is a hospital that is, the prescription is there, Lordship, and research certificate is also there, Lordship will find.
Was
Research certificate?
the permanent disablement assessed by any board?
No.
No board was
The
considered.
doctor who treated after he discharged, he treated individually, Lordship.
Private doctor.
Yes, not private. He's saying that the judgment evidence is there. Lordship may kindly see the evidence of the doctor. He is not a private, but he has shown in his chamber. He has seen the patient. He has seen the patient in the chamber after
that-
discharge from the Naga hospital.
That is in his private capacity,
Yes.
not in the hospital.
Yes, Lord. Because Naga hospital did not anywhere mention that he sustained any kind of disability. He stayed there for 4 days. Lordship will find 974 to 13704. That discharge, Lordship will find at page exhibit 4 as at page 35. There is nothing that sort of disability, Lordship. Page 35, exhibit 4. But subsequently it was issued after. It was issued after,
Issued by whom?
yes, issued by the subsequent doctor who has seen. He was before the court. Issued on 14/9/05, whereas accident took place on 04/9/70.
And this doctor was a competent doctor.
He is not competent doctor. He is not orthopedic. He is a simple. In the cross, he stated. The cross also, Lordship will find. PW2.
Let us come to the judgment then. everything
Yes,
is
Lordship.
clear.
Yes. Fine, the judgment, it starts from page 10 of the appealment. Meridian.
Yes.
The instant claim has arisen out of the claim petition filed by Mohammad Ritul Ali, claiming compensation for his permanent disablement caused due to injuries sustained by him in an accident in course of and out of his employment. Sri Krishna Kamal Bora is the OP number 1, the owner of the vehicle so and so. The New India Insurance Company Limited is the OP number 2, the insurer of the said vehicle. Brief facts of the case as narrated in the claim petition are that Mohammad Ritul Ali was the 23 years old and he used to draw 3,900 only as monthly salary, inclusive of daily allowance at the time of accident. On 9/7/2004, the claimant boarded the
He
vehicle
was
number.
working as what?
It's a cleaner. He's saying as a cleaner in the claim petition, but evidence he stated as handyman. In the claim petition, it was a cleaner.
Doesn't-
On 9/7/2004, the claimant boarded the vehicle number so and so minibus as a cleaner and was proceeding from Hosai towards Nagaon with passengers. In order to save the vehicle from collision with another vehicle coming from the opposite direction, the driver turned the vehicle to the left side, but suddenly due to mechanical defect, the vehicle turned turtle on the roadside left side, reached at the Stulguri Bridge under Nonoi police outpost at about 12 noon. As a result of the accident, the claimant sustained multiple grievous injury on his chest, left hand with wrist joint. He was admitted into BP Civil Hospital, Nagaon as indoor patient as W3 M4 and stayed there till 13/7/2004. The police on Nonoi Police Station Outpost registered a case as Nonoi Outpost DD number 124 so and so. The vehicle was insured with the New India Insurance Company Limited by policy number so and so. The claimant has not received any compensation from the OP number 1, hence has filed claim petition claiming compensation 2 lakhs only from the OP number 4 for his permanent disablement. On receipt of this claim petition, the case was registered as NWC 115/04 and opposite parties were served upon notices for submission of the written statement. Both the OP number 1 and OP number 2 submitted their respective written statement. The OP number 1 in his written statement denied the employment. This is the owner's written statement. Denied the employment of the claimant as cleaner handyman in his vehicle. He also denied the accident of the vehicle on 9/7/2004, but he admitted that the vehicle was duly insured with the OP number 2, right policy number so and so, and valid up to 9/4/2005. Therefore, he denied any liability towards the claimant. The OP number 2, the insurance company in its written statement has denied the contents of the claim petition. It has not denied the contents of the claim petition, and in respect of its liability towards the claimant, the OP number 2, its written statement stated that the liability of the answering opposite party is subject to due fulfillment of terms and conditions of the policy. Further, breach of conditions, specifically those which are provided in section 149 to 198 cell insurance OP from any liability together under so and so state policy time of the hearing. This is the,
Two PW,
yes,
claimant and the doctor.
yes, two PW, the claimant examined two himself, he
The
himself
doctor.
examined and the doctor. Dr. D.N. Hajorika.
Right.
Then discussion and decision thereof. Lordship.
Yes.
Issue number 1 and 2, the claimant in his claim petition pleaded that he was the handyman in the vehicle, was under the employment of OP number 1 and he sustained injuries in an accident on him in course of and out of his employment. In course of evidence on record on 2012-2005, they repeated the said statements. Further, in support of his statements, he produced the AIR as Exhibit 1. The OP number 1, the OP number 2 in their pleadings denied the claimant as workman, the said vehicle and his accident. Other than the denial plea in their written statement, they failed to produce any contra evidence to prove their pleadings. Under the circumstances, on perusal of the position of the claimant and the documents produced by him, I am of the opinion that the claimant has proved the conditions under Section 3 of WC Act, and it is proved that the claimant as a workman sustained injury in a vehicular accident in course of and is out of his employment. Accordingly, the issue number 1 and 2 are decided in favor of the claimant.
What is one and we will come back.
State vehicle and his accident, other than the denial plea of written statement, they failed to produce. Therefore, this 1 and 2 issue is, it is proved that the claimant as a workman sustained injury in a vehicle accident, course of out of employment. Then issue number 3, Lordship, The claimant in his claim petition and his deposition stated that he sustained injuries in wrist joints, chest, and other parts of the body. In support of his claim, he produced certain medical documents, X-ray reports and Exhibit 2 and 3, discharge certificate from BP Civil Hospital, Nagaon, Exhibit 4, and physical disablement certificate as Exhibit 5. He also exhibited X-ray plates and a number of doctor's prescription. As per Exhibit 4, he received treatment in the BP Civil Hospital, Nagaon from 9/7/2004 to 13/7/2004. The claimant also received treatment from Dr. D.N. Hazarika. Dr. Hazarika also adduced his evidence and examined himself as PW2. In his deposition, he stated that he offered treatment to Mohammad Ritul Ali, aged about 23 years, on 14/7/2004. He found the following injuries, that is, polys fracture of left wrist joint as per X-ray report number so and so dated 9/7/04, fracture of right fourth fifth rib of the chest as per X-ray report so and so, small multiple abrasion on the both hands, lacerated injury on the left leg. As opined by doctor, injury 1 and 2 were grievous nature. The injury 3 and 4 were simple in nature. The doctor offered him treatment till 14/9/05. He issued the Exhibit 5, the disablement certificate, to the claimant, which was proved by him. He also proved his signature as Exhibit 5(1). The PW2 clinically examined the claimant on 14/9/05. 14/9/05, and he was of the opinion that the claimant had suffered 30% physical disablement, and for this disablement, his earning capacity would be reduced by 40%. In view of the above facts, I am of the opinion that the medical documents produced by the claimant and the evidence of PW2 have proved the injury of the claimant and it is resultant disablement. Accordingly, it is decided that the claimant sustained injury in an accident and his physical disablement was 30%, and for this disability, he had lost his earning capacity to an extent of 40%. Issue number 4 and 5. The claimant was not produced any document to prove his age. Therefore, I have accepted the age of the workman as 23 years on the basis of medical legal papers. I have accepted the existing rate of minimum wages for a manual worker like handyman, and accordingly his salary has been accepted as 3,000 per day, 100 per day. From the foregoing discussion, it is proved that Mohammad Ritul Ali, the claimant, was the workman under the employment of OP number 1 in the vehicle number 22, and he sustained injury in a vehicular accident in course of and out of his employment. In the circumstances, the claimant is entitled to compensation from OP number 1, the employer. The OP number 2, the insurance company, has not denied the coverage of insurance policy with it. Moreover, it has not produced any evidence to prove in terms and conditions are violated by the insurer. Consequently, the OP number 2 will indemnify the OP number 1 and pay compensation to the claimant. The compensation payable to the claimant will come as under. Now, 60% of rupees 3,000 into 219.95 plus, that is the factor is factor, into 40%, it comes to rupees 1,58,364. In addition to the said compensation, the claimant will also be entitled to simple interest 12% per annum on the amount of compensation from the date of adjudication till the date of realization. Then order, in view of the above discussion, claimant will be entitled to for compensation 1,58,364 along with 12% interest. Pay the compensation to the claimant. Deposit the same. This is the award letter. Let me kindly see the evidence of doctor.
You find there are merits in the report, but ultimately it boils down that the award is of 1 lakh.
That is true.
If we can accept your argument so far as the disablement is concerned, this certificate by a private doctor given in his private capacity,
And on presumption, Lord.
that perhaps cannot be accepted. But that will reduce by how much? What will be the reduction if we hold that the disablement has not been proved? The earning 3,000 per month cannot be helped.
I leave up to your lordship.
No, what if you remove the disablement part?
It will come to 3,000, 60% of 3,000 into 219.95.
What will be the amount? Is this calculation correct, madam? I think so. Is the calculation by multiplying it 40%, correct?
Wrong thing. 60% of 3,000, Lordship, it will come
By 100,
60 by
3,000.
100
Six
into
is the
3,000.
006 is the 18. 60% of
18,000.
3,000 of 60% can be 1,800.
Yes, 1,800.
Yes. Then into
1,800 into 219.95.
yes, how much?
It sounds more. 395,910.
Hmm?
It
It's
sounds
the wrong
very-
calculation.
Yes, sir.
40% means 40% is 40 divided by 100. You are reducing the entitlement. You hold 40% disablement, you cannot multiply it by 40%.
Yeah.
The wrong calculation. I for the claimant. Claimant should have come here.
Yes, sir.
How do you calculate in case of permanent disablement?
This is the procedure, Lordship. 60% if injury case, that is 60%, Lordship, of the income, then the factor, then the loss of earning.
Loss
So
of
far as
earning.
injury is concerned.
Loss of earning is how do you calculate it? If it's 40%, will you multiply it by 40%? It will be reduced.
Yes.
Cannot be reduced. If somebody loses his earning capacity by 40%, the award
Calculation is
will be enhanced. It cannot be to the prejudice of the workman that he has lost 40% earning, so his and the award will be less. Multiplying by 40% will reduce it. What is the
Then,
calculation?
Lordship, kindly take up this on another other day, Lordship.
No, it's a matter of calculation. Yes,
Yes,
anybody, Mr. Goswami? In case of disablement, how do you make the calculation? Simple. Maybe in an MSCT or even WC, it doesn't matter.
Section 3, subsection 1, 3. Last percentage of that permanent disability.
No. How do you make the calculation? How do you come to the figure?
It is, Lordship, section 4, page number 9 of the
Now,
Act.
suppose 40%. 40% disablement here. It's an admitted to 40%.
Has to be converted into functional disability then loss of earning capacity.
Yes, loss of earnings, loss of earning
Loss of earning
40%.
capacity, what would be the loss of earning capacity if it is 100%? Then 40% of the schedule 1 gives loss of total disablement is deemed in case of
Suppose in this case, he in the WC case, he was earning 3,000
Yes.
per month. Okay, the as per the WC, it's 60%
For injury.
into 3,000.
Yes.
Into the multiplicand is 219.95 as
Yes.
per his age. Now he has suffered 40% disability. How do you
first lordship has to call 60% of
3,000?
3,000.
That is 1,800.
That is 1,800.
Yes.
Is in case of a total permanent disablement, total complete permanent disability will be 1,800.
Yes.
40% of that 18 into the relevant factor. And in the case of complete permanent disablement, total permanent disablement, that will be 1,800 instead of 3,000. In case of death, it will be 1,500.
Can you multiply it by the multiplication?
Relevant percentage determined by the
219.95. So if he has not suffered any disablement, then what will be the
considered temporary disablement?
now what will be the amount?
If there is no, then there will be no award under the head of disablement. There will be a compensation separately for temporary disablement for lasting for a few weeks, 7 weeks, 5 weeks, etc. Up to a period of, I think it's mentioned up to a period.
It is in 4.1 D law. That is
Temporary.
Disable. Lordship, it has come the correct. This is 1,58,364. After doing 60%, Lordship, 1,800, then total of 40%, it comes to 720, then into by multiplied by factor. It comes to rupees 1,58,364.
Now, if this 40% is not there, he has not suffered any development, then how much should pay?
Yes.
If we
Yes, yes.
accept the submission that the disablement has not been able to be proved,
So that 1,800 to the direct multiplication. Yes. Then it will come to Lordship, will come paragraph 4(1)(d).
what would be the calculation?
But that is a half monthly payment it is given. Where temporary disablement, whether total or partial results from the injury. That is in case a half monthly payment of the sum equivalent to 25% of monthly wages of the workman. Then it's stated in 2, the half monthly payment referred to in clause D of subsection 1 shall be payable on the 16th day from the date of disablement where such disablement lasts for a period of 28 days or more. After the expiry of a waiting period of 3 days from the date of disablement where such disablement lasts for a period of less than 28 days, and thereafter half monthly during the disablement or during a period of 5 years, whichever period is ordered. But here in our case, Lordship, only 1 month, the doctor asked to take rest for 1 month. This is half the monthly wage, Lord.
Will, in principle, will allow this, but we not touch it. 1 lakh it is not much. If we go by that calculation, now did you pay anything? The entire
Yes,
amount we had
yes, yes.
deposited.
No, we have given 50%
50%. At the time of
admission.
filing.
Admission, yeah. At the time of admission, Lordship.
And do you make any submissions on the,
Yes, it is
Uh,
7/11. Order is there. Lord.
no, they do you have any submissions on the interest part?
Interest part,
12%.
that is not Lordship, that is in the higher set, Lordship, 12%, 9% is given.
That was not one of the questions.
Here it is admitted, stay granted, deposit of 50% before the rest you have deposited, Lordship. I think they have not withdrawn the money.
The instant appeal has been heard under section 30 of Workmen's Compensation Act 1920, within bracket present Employees Compensation Act 1920, bracket close. Again, a judgment dated 79/2007 passed by the learned commissioner, Workmen's Compensation, Nagaon in NW case number 115 of 2004 by the aforesaid judgment, the learned commissioner has awarded a compensation of rupees 1,8, has been with 12% interest. Full stop. New paragraph. This court, while admitting the appeal by order date 7/11/2011, had framed the following substantial questions of law. 1, 2. Order it is 7/1. New paragraph. I have heard M. Chaudhary, Learned Counsel for the appellant. None has appeared for the opposite party in spite of service. Full stop. This court had also passed an order dated 19/2/2020 regarding completion of service. M.S. Chaudhary, the Learned Counsel for the appellant, has submitted that with regard to the first substantive question of law, comma, there are certain relevant case laws, full stop, by placing reliance upon the case of Oriental Insurance versus Lakshmi Das, reported in 2006, 3 GLC 870, in which the Honorable Division Bench of this court had held that wages would not include the daily allowance. Full stop. The Learned Counsel has, however, also based on record the decision of the Honorable Supreme Court in the case of ... reported 2011 1S 304, in which such daily allowance has been held to be part of the wages. Full stop. The Learned Counsel, however, also placed reliance upon a subsequent decision of the Honorable Supreme Court in the case of ... reported in 2017, 15S 590, wherein it has been again laid down that wages will not include the daily allowance. Full stop. Following the same decision, comma, this High Court has also passed an order dated 3/9/2009 in MFA 19 of 2010. New pair. The learned council has, however, fairly pointed out that both the aforesaid judgments of the Honorable Supreme Court are passed by benches of equal strength, and it also appears that in subsequent judgment of 2007, the earlier judgment was not brought to notice. Full stop. New pair. Be that as it may, the learned council submits that the computation of the compensation by including the daily allowance as a part of the wage is not permissible under the law and requires interference. New pair. As regards the second substantial question of law regarding disablement, wherein the loss of earning capacity has been held to be 40%, the learned council has submitted that such assessment has been done on the basis of a certificate issued by a doctor in his personal capacity. Full stop. It is submitted that there is a procedure prescribed for ascertaining disablement, and the same cannot proceed on the basis of any presumption.
Lordship, here it is on presumption he is assessed. It is cross he is admitted.
The learned council has further pointed out that the doctor who was examined as PW2 in his cross-examination has admitted that the assessment of the factor of disability
As well as loss of
has been done on the basis of presumption. New pair. The learned council according to submit that the second substantial question of law is also liable to be answered in favor of applicant. In the instant case, the claimant had made a claim on the basis of sustaining injury in an accident occurring on 9/7/2004 concerning a vehicle within bracket minibus bracket close bearing registration number AS-0/960 in which the claimant had claimed to be working as a cleaner / handyman. The record also revealed that till 13.07.04, the claimant was an indoor patient in the BP Civil Hospital, Nagaon, and in that period, there was no assessment made with regard to any disablement suffered by the claimant. New pair. As indicated above, none of opposite parties have come forward to contest the present appeal. New pair. The contentions advanced by MS Chaudhary, the learned counsel for the appellant, have been duly considered, and the materials placed put forth, including the LCR, have been carefully produced. Full stop. New pair. As indicated above, as per requirement of section 30 of the Act in question, the appeal was admitted on two substantial questions of law which have been indicated above. New pair. With regard to the first substantial question of law, the case clause placed before this court would reveal that there is no consistency, full stop, consistency in the full. It further reveals that the earlier decision of the Honorable Supreme Court in the case of 2011, in the case of ... was not even brought to notice when the case of ... was being considered at a subsequent stage. Full stop. Being confronted with such a situation, this court had taken the recourse of having objective of statute in mind, which is a beneficial piece of legislation meant to protect the workman at the time of suffering any injuries or his family in the event of death during the course of his employment. Therefore, this court is of the opinion that the interpretation which is in favor of the workman would be preferable, meaning thereby that the wages should be held to be inclusive of daily allowance. According to the first question of law formulated by the court stands answered in favor of the claimant. New pair. With regard to the second substantial question of law, this court finds forth in the argument of the learned counsel for the insurance appellant, insurance company, appellant, that there is no material prescribed by law to justify the assessment of 40% disablement, including such disablement with regard to loss of earning capacity. Full stop. Therefore, comma, the approach of the learned commissioner in accepting the aforesaid contention with regard to %40 disability regarding loss of earning capacity does not appear based on relevant material on record. Full stop. Therefore, this court is of the opinion that the second substantive question of law is to be answered in favor of the appellant. Full stop. This court is according left to decide on amount of compensation granted by impugned judgment and awarded 17/9/2007. The award is of an amount of rupees 1,58,364 as indicated above. Full stop. The accident was of the year 2004 and the judgment is of the year 2007. Full stop. Under those forces, facts and circumstances, comma, while answering the substantive question of law, comma, this court is of the opinion that taking into account the aforesaid factors, comma, the amount in question may not be interfered with, and according the same is sustained. Full stop. At this stage, comma, the learned counsel for the appellant has submitted that 50% of award was deposited at the time of admission of the appeal. Has it been withdrawn? Has it been released?
It is before the WC Nagaon.
Has it been released
I have not seen.
before the Workmen Compensation Commissioner, Nagaon? Therefore, the insurance company is directed to deposit the remaining 50%. It further clarifies that the interest granted would accrue only upon the balance 50%, which is left to be deposited. The claimant would be entitled for release of amount from the learned Workmen Compensation Commissioner, which will represent Employees Compensation Commissioner Nagaon in accordance with law and on the property identified by his counsel. Appeal according to
This the amount
Para-
will deposit
the-
before the
healthcare may be sent back. Court will.
but the balance amount will deposit before the commissioner and WC Nagaon.
The balance amount as directed above to deposit court WC Commission Nagaon within a period of 60 days along with.
Obliged.
Next. Next also you are there. Item 3. Number 3. Who is this 3? Item 3. And 4. You for the appellant and the other side. Regulate council. Legally. Where is he, Mr. Rajiv Dev? Rajiv Dev, R. Dev. Who is in 3? Oriental.
Is not there yet. Oriental.
Oriental.
Is not operative.
Mr. Ahmed had
Yes,
filed. Ahmed had passed away. So
Yes, yes.
there somebody else needs to take guard. Who normally appears for Oriental? You appear. Take the instruction. I don't know. None appears for the party on court. This court is however informed that the Ahmed Senate Council was conducted on behalf of appellant dash as Oriental has passed. That the interest of the matter is according to John by a week to enable the appellant to engage any other counsel. This after under column top of the within informally you take it. We are not recording your name because it's only a panel. So it may not look good. Take it. And 4.
Let's say I'll inform him, but then it may not be possible today if he is not prepared.
But is he been informed? So his name is also there. Now, if he's not interested, we'll have another legal aid counsel.
That's what I have to ask him.
This is not expected. Legal aid counsel have to give more preference to a legal aid matter. His name is also recorded.
Yes, because R1 had not, after appearance, the counsel for R1 did not appear directly.
We'll have it at 2 o'clock again. If he is present, well and good. Otherwise, we'll direct engaging of another legal aid.
I'll try to, I don't know his number, but I'll try.
Yes.
Now, here, my lord, we have challenged the input order that your lordship will find at page 43.
You are what? What is the suit for?
Lord. Lord, lordship will find the plaint at page 12.
What is the suit for? Tell us. You are who? Petitioner is what? Plaintiff. You are a defendant.
Defendant. Lord, suit for declaration of right, title, interest, and declaration of that cell deed number so and so.
Suit for declaration of
Right,
title
interest. And my lord, declaration that cell deed number so and so dated void, inoperative, and invalid.
and challenges still did.
Yes.
Dated,
Sell date, my lord.
dated, date of the sale,
Date is not, my lord. mentioned.
number is there.
Number is there, my lord.
What is the number?
Number, my lord, sell date number 221 of 2015.
As inoperable. Okay.
Yes.
Then what happened?
And another sell date, my lord, 222/2015. And my lord, 407/2015. Three
Three.
dates.
3 days.
3 dates.
These are all registered sales.
Register sell. Now, lordship, find, my lord, the impugned order at page 43.
What happened? You tell us.
Now, initially, my lord, there was a, my lord, IA for, my lord, amendment certain portion in paragraph 36A that was rejected by the, my lord, trial court. And after that, my lord, second time,
Who they had filed an IA,
yes,
plaintiff
plenty
for amendment.
amendment.
IA number
IA number, my lord, page 36, lordship will find.
36.
Yes.
Yes.
That was rejected.
Nijje case to 22.
Yes. Page 43
22 of 18 for amendment.
for amendment. That is, my lord, 36A for degree of confirmation of possession and degree of permanent injunction in favor of the plaintiff.
Rejected on 15/9.
59.
Petition rejected.
Yes.
Yes.
Order.
Thereafter,
Thereafter, my lord, second petition has been filed.
this was under Order 6, Rule 17 or what?
Yes.
Then what happened?
Then, my lord, subsequent petition has been filed that your lordship will find.
After rejection of this,
Yes.
another petition.
Another petition.
Page?
That your lordship will find at page 38.
New petition
Yes.
for under Order 6, Rule 17.
Yes. And prayer lordship will find at page 39, para 7. Page 39, para 7. That the amendment sought for is as follows. In paragraph 36A, the following lines should be added for a degree of confirmation of possession of the plaintiffs over the suit. Same. And that has been, my lord, allowed by the, my lord, trial court, which is barred by red duty kata under section 11.
Allowed by which order?
Page 43.
They had filed written objection.
Yes. Everything was there. Written objection was filed. That is at page 41.
Yes. It is the order
Order is page 43, my lord.
dated 12/12.
12/12/2018.
Yes. Allowed.
This is allowed.
Mr. Das, at 2 o'clock. Will not take much time.
No.
As to title on merit suit confirmed by the order of the High Court.
Yes.
The High Court had dismissed on the grounds of limitation or not taking steps, even though it will stay as a, it will act as a residue.
No, it was because the question of title was decided by the trial court. That was dismissed on the ground of limitation. In that context, it was decided. Now, in our case, it is in the preliminary stage. Amendment is sought for. Suit has not been yet decided.
Anything else?
My lord, And my lord, it is an interlocutory order otherwise. 115 is a bar. That does not mean that 227 power should be exercised at the drop of a hat as it has been held by the Supreme Court. The Supreme Court also has taken note of the fact that since 115 has debarred against interlocutory order, therefore, we should also be careful enough to see that pools of justice are continued and no superintendent is required for. It is very clear. My lord, your lordship is to
Lord,
see
yes.
2010 8 is
In the case of Virudnagar, do you have Virudnagar,
period of that.
Honorable Justice Nariman?
Let us see.
I don't know the citation. What you have just submitted, that has been elaborately explained. Yes, if the court gives you remedy, then you cannot take recourse to 227.
Yes.
But here the court does not give them remedy.
No, in
It's an
this
interlocutory order to 115 would be barred. So if you invoke 27, he has to make out a case. Burden is upon Mr. Mondal.
Yes.
We'll be very strict on the burden.
Yes,
But if we find that there is a jurisdictional error,
yes, yes.
because
Definitely your lordship. But here in this case, A, B, C, D, E, F, G, H, have about 17 cases has been 17 instances have been given. Shalini Shoni, 2008, 2010, 18. Let me check.
which one? Which paragraph?
My paragraph 48, 49, 49, A, B, C, D,
2010.
E, F, 2010, 8 SCC, 329.
329. Shalini Shyam.
Shalini Shyam. Paragraph 49, J,
49J.
J, M, and N.
Paragraph?
Paragraph 49.
Not something.
My lord,
This legal is different. How does it start?
it starts on an analysis of the aforesaid decisions of this court. The following principles emerge. Later,
Yes, this is paragraph 62 here.
oh,
It's a different. Doesn't matter.
I'm sorry, sir.
SCC is paragraph?
Paragraph 49.
Yes. On an analysis.
And
Yes.
of the aforesaid decision, the following principles on the exercise of the power of jurisdiction of the High Court under 227 may be formulated. ABC. High Court cannot, at the drop of a hat, in exercise of its power of superintendence of 227 of the Constitution, interfere with the orders of the tribunal or the court inferior to it, nor can it, in the exercise of this power, act as the court of appeal over the orders of the court or tribunal subordinate to it. In cases where an alternative statutory mode of redressal has been provided for, that would operate as a restraint on the exercise of the power by the High Court. Then,
Yes,
your
yes.
lordship,
But can he be left with remediless? Where there is a right, there is a remedy.
That is the, it is also clear. What there is a right, that is
We just remedium.
remedium. That is correct. But the purpose is that your lordship would be very slow to interfere.
Yes, yes, you're correct.
That-
227 is cannot
that
be a
is
matter of
But
force.
nobody can be without any remedy.
No, you are absolutely right in contending the 227 cannot be a matter of force.
Yes,
It has to be circumspection.
yes,
They have to discharge the burden.
yes. Now, your lordship, please to say J, it has been clarified. J,
Yes.
it is maybe true that the statutory amendment of a rather cognate provision like 115 of the Code of Civil Procedure,
You're right. Right?
J of the J. That- Therefore, my submission is that it is not an exceptional case in which your lordship may like to interfere with the order of the tribunal or the order of the lower court. This was the case at the previous stage when the suit was yet to be decided.
But we are not on the decision of the suit. We are
No,
on the decision of the amended application.
amended
And res judicata application, there is not a disputed res judicata
applies in the same proceeding. Two stages in the same proceeding.
any stage.
Yeah. Two stages in the same proceeding. it applies.
Reasonable. Yes, yes. 2019 9 SSC 538.
2019, 9
9 SSC 538. Read paragraph 13 here. I am doing.
much obliged.
The remedy has to be in this court. Then 227 bar becomes absolute. The next page, paragraph 30.
Yes.
Continue.
But the question of power is already there. But the question is
Self-restraint.
that your
Self-imposed
lordship,
restriction.
yes, more or less. Your lordship will be very slow to interfere. Otherwise, the people will be remediless.
Because if you are on this side, it will be difficult. tomorrow, if you are on this side,
I know my limitation.
remedy has to be there if there is a violation of right.
Yes. Huh?
Anything else?
What? Oh, it was with pause.
Hmm?
The input order was passed with pause at page 48.
Yes. If this goes, the cost also goes. We may not have time to dictate the order. We'll pass the order on today's date. MA1 whereas the respondent are assisted by PC does assisted by as of the arguments are considered.
Develop.
Your lordship is rising at T.
Slightly early, there is a meeting. Whatever is able to be completed will come. What is the
May please, your lordship. Your lordship, see the impugn order in the IA, page 26.
is
26, Annex D. The decree holder is presented by petition number so and so. The decree holder has submitted that in the supervises, which is to be executed. There is electrical connection which is to be disconnected. At the time of execution of the decree, the decree holder has prayed to direct judicial flow for Nazi to disconnect the electrical connection in the supervises. By petition number so and so, the decree holder has further prayed to allow him to deposit cost of the police for executing the decree. I peruse the case record from the perusal of the case record. It appears that the court Nazi prayed for police assistance to execute the decree. Hence, pair of the decree holder is allowed. The decree holder is to deposit the cost of police assistance along with the fresh rate. Decree holder has to take fresh steps for disconnection of the electric connection at the decree should then. This is the related provision. And page 24 is the petition filed by us. Page 24.
yes.
That the opposite party, Kishan Gopal Agarwal has filed a present execution proceedings being action number so and so before this court. Thereafter, the present petitioner filed a petition under order 21 to 97 and 19 read with petition 51 of the CPC by claiming that the should then include the land of the petitioner and he had been posing the same since the day of their petitioner. And the said petition was registered as mistake case number so and so in connection with the present execution case. So after receiving the copy, the decree holder Kishan Agarwal received the copy of the petition and filed written objection. In a said MJ case number so and so, the petitioner Babul Rahman adduced evidence and the civil Nazi of the reported that the judgment letter has not decided over the suit land. More than that, the civil Nazi of the court had already adduced evidence upon the same. Now, under such circumstances, the exempt proceedings can be proceeded as per law. The present petitioner have filed two petitioners. It appear to not to issue police force protection till disposal of the MJ case, who is being registered as MJ case number so and so and MJ case number 6023. But both the petitions were rejected by this honorable court, and the present petitioner has filed a revision petition before the honorable Guwahati High Court. And our honorable High Court has admitted the petition number so and so, and the next date is fixed for after 4 weeks. And the case of the order 2197 petition is annexed to issue an evidence case. Annexed to case 31. This is pending before the London Executing Court.
But stay was not granted in the revision petition.
But subsequently, this order has been passed.
You had the prayer for stay.
Subsequently, this order has been passed.
Obviously, since there is no stay of the proceedings,
What-
order has to be passed.
But because in a order 2197 petition, it has to be decided under order 21 105.
without deciding the issue, if the main issue is in the civil revision. You had a prayer for interim order. Subsequently, this order has been passed. This order has been passed after filing a revision petition. This is in the IA. This is passed on. If there is no stay by the High Court, won't the court proceed? So I pray before deciding the revision order 2197, because Nazi has given a report. We cannot grant expert order. Because notice has been issued recently. We cannot grant expert order. Since if your case was that in the main revision petition, there was an interim order, in spite of which this order has been passed, matter have been different. Only notice was issued. Heard. Yes, sir. Basically, one judgment, Mohammed Sodri and this. Before this is not a question of judgment; it's a question of propriety. Tomorrow I will evict because in this Sanyal case, if these are facts, we can just change one thing. We can issue notice. One thing, because tomorrow I will evict because the police will be there. Tomorrow I will nothing will be less. Because that was your cause of action in the civil revision. You paid for a stay. It was not granted. So let's see the annexa 14 without any order being granted in the substantial petition. Who are the proceedings? Can we stop a subsequent action? We cannot. You see, this Mohammed Sodri's husband, the order is decided under section 1. That is a question on merits of the civil revision. You have the civil revision for expeditious hearing. So subsequently, this order has been issued. Tomorrow I will be evicted because there will be nothing less. This such one of the judgments. There is a decree by a competent court. You come under 2197. Yes, sir. Now in 2197 there is no protection. You come to the civil court, the High Court, in the revisionary jurisdiction. No interim order is passed. The executing court, they proceed. Now how can we? We can issue notice. One line of the judgment. One line. Only one line of the judgment. Your LCBC. Because the judgment is not going to help you. Because Nazi report has said that we are not going into the marriage. Can we go into the marriage? Only for 2 weeks. Only for 2 weeks, I mean protected. Because after hearing about the parties, if the court finds the right moment, I may be rejected. Only for 2 weeks. In the meantime, I will be evicted. Because in the meantime, this order has been issued. Senate counsel for the petition who has filed this application under section 151 of the for stay of an order dated 11/9/2023 passed in title execution number 13 of 2014 by the learned civil judge Nagaon. It appears that the petitioner, the applicant, has filed the connected civil revision petition being aggrieved by the orders dated 19/8/2023 by the learned civil judge Nagaon in Mijay case, in certain Mijay cases, and further orders passed in the title execution case, in which this court, by the order dated 7/9/2023, had issued notice. Full stop. No notice, however, has been issued on the prayer for stay. Shri Gogoi, the learned counsel, by drawing the attention of this court to the order dated 11/9/2023, has submitted that if some interim protection is not granted, the applicant would be evicted. Issue notice returnable on on 9th of October
In the meantime,
2023. That steps be taken for service of notice upon respondent by registered post date. The petitioner is also at liberty to serve justice upon respondent, which however but routed through the registry of court and the notice accompanying justice to clearly reflect the next date. Para. The Google please for an interim order. Para. Considering facts and circumstances, in the interest of justice, provided that till the returnable date, the order date 11/9/2020 be suspended. Shall remain suspended. Para. Since this order has been passed expert, comma, the respondents may come up for alteration, modification, vacation of the same. In any case, comma, the aforesaid direct for would be reconsidered on the next day. Applies. The day your legal aid counsel, you're not there.
Okay, I'm very sorry, Lordship. In this case, Lordship, I am not. That's why was happened.
You're not the legal aid counsel.
Earlier I was, Lordship.
Now you're not.
No.
Who's there?
Yes, Roy.
Astroy. Who is Astroy? Name not shown.
Sanchita Roy,
Name not shown. By which order?
last order, Lordship.
We have the name of asteroid reflected. Third, we are to similar count for the apple. Full stop. Do this court. No. When this matter was taken up by the court on 3/11/2020, on noticing that the appointed legal aid counsel was not present, MS Astroy, learned counsel was requested to assist the court, which he had readily accepted. Para. The aforesaid order has also been referred to the RD, whose name is reflected in the cause list. The cause list, however, does not reflect the name of MS Astroy. Please display under the column top of the here on Tuesday next. Tuesday. On Wednesday next.
Wednesday.
Date.
Okay.
May I please you?
Yes.
By this appeal, my lord, I have challenged the validity of the judgment and
You're on caveat, Mr. Bhunia.
yes,
Lordship.
I gave it may kindly be discharged.
Art Bhunia. Learned counsel for caveat have lost, the caveators who have lost this caveat, who are the judgment dated 8,000 passed by the learned district judge, Kampur, M. in type step number 30 of 2000, by which the appeal has been allowed.
Yes.
Appeal has been allowed.
Appeal dismissed.
Appeal was dismissed.
Trial court passed the judgment. Trial court,
In your favor,
yes, sir.
by which the first appellate court had dismissed the appeal and had affirmed the judgment of the learned trial court, which had passed the decree in favor of the caveat appeal. Caveators appeal. The caveators would heard the event this court proposed to pass any interim order. That caveat stands with her. Yes.
May it please your lordship. My lord, both the parties are related.
Related.
I constructed the building, subsequently they filed.
You are the defendant.
I am the defendant.
Appellant is the, how many appellants?
There are, my lord,
Okay,
there are
doesn't,
many dependents.
okay, doesn't matter, defendants, then
Yes. Then
good for,
suit for declaration of right and for mandatory injunction, my.
declaration of right title interest,
Yes, and for mandatory injunction for demolition of the unauthorized construction.
and mandatory injunction for demolition.
Yes.
Yes, sir.
Now, my lord, so far this case is concerned, my lord, in this particular case, I have framed the three substantive questions. Those are at page, my lord, 3.
Page?
Three.
3.
Grounds and substantive questions of my. May I read it, my lord? Whether the learned lower court are justified in holding that the suit is not paid for non-judicial of necessary parties, that is Guwahati Municipal Corporation, Guwahati Metropolitan Development Authority, and especially so in view of the judgment and decree of learned trial court, whereby the direction to the Guwahati Municipal Corporation and Guwahati Metropolitan Development Authority has been issued for demolition of the unauthorized construction that is the part of the roof of the first floor of the building and the cantilever covering the schedule B passed in absence of any prayer by the plaintiff to that effect in place. The number 2, where the learned courts below are justified to order the demolition of unauthorized construction without determination of the extent of unauthorized construction. That is the thing, my lord. Now, my lord, I am taking to your lordship, first of all, the plane. And your lordship will find the plane at page 52, and the prayer portion is at page 59, my lord.
59.
59. And 59, it starts from 59, and B is important, my lord, at page 60.
59 is part of the plane.
Yes. That is the prayer portion in the plane. And
Yes.
B is important, my lord, for our purpose. A decree for mandatory at page 60.
Yes.
A decree for mandatory injunction to demolish the said extended portion of the roof of the first floor as well as the cantilever covering the schedule B path and towards the schedule A lane and house. That is the specific prayer. My lord, now I am taking to your lordship to the judgment of the trial court, my lord, at page 15.
15.
No, sorry, my lord, at page 31.
31.
31. And the order is at page 43, my lord. Page 43. Page 43. Order which has been passed.
Yes.
TS number order, my lord, last part of. TS number is decreased and disposed of on contest before. It is declared that the extension of the roof of the first floor of the building as well as the cantilever covering the Schedule B part is illegal and unauthorized and liable to be given. The GMC and GMDA are directed to demolish the unauthorized construction in violation to the NOC detestation clause and demolish the part of the roof of the first floor of the building and the cantilever covering the Schedule B part which was extended in deviation of NOC detestation clause. That order has been passed now. Since then, your lordship has already seen that there is no pleading at all in respect of direction to the GMC or GMDA, and it is beyond the pleading. The relief which has been given is beyond the pleading. First point. And accordingly, my lord, in view of this position, the GMC and GMDA are the necessary parties to the suit, and that point has also not been discussed properly, my lord. That your lordship will find the issue number 3, whether the suit is made for defect of parties, that your lordship will find that page 17 of the appellate order, para 15. It starts from para 15, my
Page
17,
117,
17 of the appellate order. Last, my lord.
Issue number 3.
Yes, issue number 3. This issue relates to the fact that the suit is paid for defect of parties, and learned trial court decided the suit is not paid for non-joint of GMD and GMC, who are the proper parties to the suit. Hence, it is seen that the learned trial court opined GMC and GMDA and GMC as proper parties to the suit and answered the issue in negative and in favor of the plaintiff respondent. The learned counsel appearing on behalf of the appellant during argument extensively submitted before this court that GMDA and GMC are the necessary parties to suit, and in the absence of no effective decree can be passed. The learned counsel for the appellant further argued that the learned trial court ought to have dismissed the suit due to non-joint of necessary parties. In the backdrop of the submission made by the appellant side, this court has carefully reviewed the entire case record, from where it finds that the plaintiff's respondent instituted suit for declaration that the construction made by the defendant appellant over Schedule C lane without keeping the side margin towards the Schedule A lane and extending the roof of the first floor of the building and the cantilever covering the Schedule B part as illegal and unauthorized. Admittedly, the plaintiff have not implemented GMD and GMC in this suit, and no relief also paid against them by the plaintiff. The settled proposition of law is that a necessary party refers a person in whose absence the court is unable to adjudicate a clear point of controversy between parties, and in whose absence no relief can be granted by the court. The learned trial court opines that both the GMDA and GMC are the proper parties in whose absence the court is able to dispose of this dispute in hand. A proper party in a suit is a person whose presence may be required in deciding.
Yes, we have read.
Yeah. So, my lord, I have claimed that two issues. First of all, beyond the pleading, the relief which has been given is beyond the pleading. And second question, without determining what area is to be demolished. So that these 2 points in support of this contention, my lord, if no relief is claimed in the pleading, my lord, whether such relief can be given, my lord. In support of this, my lord, recent judgment, my lord, 2023 for SCC, page 788. And directly, my lord, I am taking to your lordship to paragraph 31.
Just a minute. But this question of yours, which you're trying to raise, this become redundant in view of issue number 3. Issue 3 was specifically on this point.
On the
whether the suit is bad for defect of parties.
party. Now the direction
Both
has
the
been-
courts have decided against you. Both the courts,
yes, court has decided this issue.
it is not
against
that
me.
issue was not framed, issue was
The
framed.
issue was framed. It is not my question that the issue was not framed. The issue was wrongly decided.
Now we have
That-
to, you have to make out a case that the findings of both the court in holding GMC and GNDA as proper parties and not necessary parties is perverse. What is the role of GMC or GMDA in the adjudication process?
My
There is
lord,
no role.
no role. Then where is the question?
It is
of
only at the
direct-
time of execution.
No.
Their
Then,
role may come
nine. Where is the
for
question that?
adjudication of the list. There is
No,
no role of the
my,
GMC.
my lord, then where is the question that the GMC and GMDA are to be directed by the learned court below, my lord?
So who will demolish?
It is
The-
my,
the
myself.
plaintiff-
Mandatory injunction is given to me. It
That
is
is-
I who will demolish. If I do not demolish, in that case, he can execute the decree through the court for demolition of it.
Will you undertake to demolish?
Huh?
Will you undertake to demolish?
My lord, it is a different question. But
No,
now
if
the
you
que-
say that
na-
that part is not
now the
not proper, you undertake to demolish within a month, will stay this.
no. But my lord, the question whether such direction can be issued to the GMDA or GMDA without any prayer to that effect. That is the vital question of law. And secondly, my lord, the question equally involved. Now, in support of it, I beg to refer the judgment, my lord. Your lordship may come to para 31.
Just you are referring to BSTS, Rajdhani.
Yes. Para 31, my lord.
Para 31.
Yes, my lord. Paging is not there.
Doesn't. Yes.
Para 31. Thus, in a second appeal, the appellant is entitled to point out that the order impugned is based in law because it is the host of pleading. The host of pleading, or it was based on no evidence, or it was based on misstating of material document evidence, or it was recorded against the provisions of law, or the decision one which no judge acting judicially could reasonably have reached once the appellant court is satisfied. That is a different thing, my lord. Here it is the host the pleading, my lord. Whatever the order which has been passed by the learned lower courts, my lord. That is not, the prayer is only for mandatory injunction. And where is the question of directing the GMT or GMDA to demolish it? And without ascertaining the area of illegal construction, my lord. The area ought to have been decided, first of all.
That has been specified, the cantilever.
Country, no, it is not specified because I have been permitted to have the cantilever, my lord. For that one, I have annexed with my appeal, my lord. The last part of it, your lordship will see. Page 72 of my appeal.
See, Mr. Bhatti, your appeal, second appeal is more directed towards not on the merit of the dispute. You are on a different tangent. That this was not a part of the thing, whether it be demolished by GMC, GMC, you are on that. Why is the direction of decree by the trial court, which is affirmed by the first
No,
appellate
no
court?
doubt, my lord, but without.
You are not even addressing anything on merit that the direction is they are not entitled to, or there is a perversity. You are only on the part how will it be executed.
No, it is the only the part of the execution, my lord. I agree with your lordship.
No,
But
you
so
can,
far-
you are, see,
So far,
though second appeal, the grounds are very limited. You are free to argue on the merit that the findings arrived at is not based on materials on record. That is not your argument.
no, that is my argument, my lord, because since the order.
No, you are only on the part who will demolish. On the demolition part, you have not said anything. The prayer for mandatory injunction for demolition, which is the substantial part of the judgment, that part you have not even assailed. You will say that while demolishing, they have mentioned GMC, GMD, which is not a part of the place. That is a subsequent consequential act. We may not be too much. We may not be too much concerned with that, unless you are aggrieved by the substantial portion. The demolition itself is bad in law. They could not have given. these are the materials in my favor, not taken into consideration, or these materials have been taken into consideration, not relevant. That is not your argument.
My argument is twofold, my lord. First, the non-joined that issue has wrongly been decided. And secondly,
You have not said that, you are saying that for the first time now.
now well, that
Yeah, address this court on that, we'll hear it.
yes. And since your lordship has already seen,
Mr. Bhuyan,
Lordship, so far in non-joined have been now they have taken before this honorable court as well as appellate court. In the pleading, they have never stated the GMD and GMC and ST party. Never stated in the pleading. Number two, so for the illegal part is concerned, they have admitted that is exhibited document. Now my learned brother has submitted before this honorable court how much portion is to be demolished. That has been already ascertained by the GMC by Exhibit 12 that this is the deviation portion, and the present appellants they have admitted by examining when they have examined DW1.
aren't you related?
Yes,
You are related.
Lordship.
Why don't you settle the matter?
Lordship, now what happened?
I'm ready to settle. If
No, they are not going to settle it. Lordship, what happened? There is a 4-feet wide path.
When you say you are ready, then we have some doubt.
No.
Huh.
Not
On the garb
definitely.
of being ready will take 1 year.
No, definitely.
Listen, Lordship,
I'll be ready tomorrow.
wide path. That wide path has been covered.
But my lord,
We have objecting it,
Where
and the
is the
GMC
word?
restrained them.
Where is the property?
Lordship,
it is in 80 road.
80 road,
Soti Joymati Road, Atgaon,
congested.
congested area.
It
They
is
have
just
covered the
near masjid. Just near masjid. My lord. Very valuable land.
The
my lord.
first floor they have brought.
So, my lord, at least, my lord, I have made out a case. Substantial question of law is there, my lord.
We'll record that you have been trying to make out a case.
No, that may not be sufficient for me, my lord.
No, that will be
At
sufficient for you. We can try.
My lord,
Ultimately,
because, my lord, your lordship has already seen.
Lordship, matter may be
The-
disposed at the admission stage there. Because I have their admission.
I will submit. My lord, here is the question. The prayer portion is a different one. Nowhere in the print they have asked for demolition of the construction illegally, assuming illegally constructed by me. So GMC and GMC.
assuming you have added later. Assuming expression you have added later. You said illegally, then you said assuming illegally.
So my lord, at least I have made out a very good case. Substantial questions of law. And the third one is also there, my
You have made out the best case,
and
which
the
cannot be accepted.
the third question is also there, my lord. The third question regarding the regularization of the
Illegal construction.
illegal construction. That question I have also taken the ground, my lord. So that we can also make an application to the GMC.
That was never the issue before. In a second appeal, whether you can, as a defendant, for that matter, any of the parties, can raise something new.
My lord, new in that view, I may be given the chance to file an application before the authority for regularization.
After completion of the trial and decree there by the appeal, under what provision? You can file for it if you want. If you can make out a case for it.
My lord, whatever may be, but on grounds number 1 and 2, I have it. Because the
Normally,
has
the
to
second
be-
appeal first day we do not dismiss, but this may be one of the exceptional.
Your lordship has already gone through the judgment of the Honorable Supreme Court. If the relief given is the host the pleading, in that case it is a substitute.
We'll dismiss. But we will not have the time to discuss. Today's date only. Rest perhaps will not be able to do today. There is some meeting we have to write. Any matters, urgent matters?
Much of them.
where interim order is still today and needs to be extended for some dates,
Lordship,
our court must have received.
interim in daily list 53 and 54, interim is there.
50 to 54 paucity of time. We'll have it next week, interim order transaction. Any other matter?
Can it be after the vacation? Because next week I'm coming for free.
You are there?
Yes, 53.
Then after the vacation, interim order. Item number 50,
3 and 54.
try for whom?
For the respondent.
Very paucity of time. Did not allow the matter to take on. The party, the learned counsel of the party have acted for discussion of this matter after the vacation. That are accordingly after the vacation, interim order passed and extended.
I'd like to mention 46 item.
Interim order is there.
No, it is listed for withdrawal only, my God. Second appeal.
46 which you are withdrawing. Who is for the other side? 46
I'm for the
so for the other.
due to amicable settlement between the parties.
Yes, what do you say?
I enclose the submission.
Third 3A for third count. You have filed IA for that purpose.
Yes, yes.
For
I have
the
2761.
applicant. Your J pass.
Yep.
As well as J pass, that concept for the respondent.
Respondents. All the respondents.
Already the A pass, the concept for the applicant submit that yes, that the present IA has been filed with the instruction to withdraw the connected artist 150 of 9 as the matter has been stated amicably settled. Correct? Three J for the concept for respondent endorses this. IA according to allowed and connected artist 1,009 is according dismissed on withdrawal.
And other IA is also in fact 574.
Item number 22, 23, my lord. My lord, in orders matter, my lord. I want to withdraw my lord item 22, my lord. Since my lord, we could not serve the my lord, the notices, my lord. We tried to trustee as well as my lord raise that post, my lord. And the amount, my lord, the claim amount is only 2,300, my lord. That is why, my lord, I have instruction to withdraw.
That the amount involved is a petty one.
Yes.
And till now, the respondents have also not been able to serve. According to permit,
Item 22.
under those circumstances, the appeal which was filed there 2008 not is not being put for any purpose. If you have such substance, if you have fruitful and according here, the praise for withdrawing here. The hearing and on the appeal is not
My lord, item 22, my lord, 23, my lord, we have served my lord to Dusty, but they have not appeared. So it may be fixed for hearing, my lord.
23 we have passed out.
My item number 51, my lord.
Only 22, 43, MFA 43.
My item number 51, my lord, stay was till date, my lord. So it may be extended.
51.
Item number 29.
29. Yes. Is there any interim order?
Is for the applicant.
My lord, so far as the appealing respondent number 1 is concerned, my lord, I have taken step, my lord. But due to insufficient, my lord, address, matter is now
my lord, now, my lord, my learned senior, my lord.
He's appearing.
He is appeared, my lord, for respondent number 2, my.
One, are you appearing for one?
One, my lord.
Will you appear for one?
Respondent number one, my sir. But he appeal is proceeded against the wrong part. Wrongly named. Respondent number one is wrongly named. In the original case, his name
You
was.
make corrections, then he can perhaps appear.
My lord, what happened? My learned friend filed the title suit decreed. Now, my lord, being aggrieved, my lord, I have filed the title appeal, my lord. That, my lord, Siddhartha Barua's name is Nohayan, my lord. And in spite of Vidhan Barua, it should be Vidhan Barua, my lord. Now, my lord, entire judgment has been done, judgment delivered, my lord. Now, against this first appellate court judgment, my lord, I have filed, my lord, second, RSM
It should have been Vidhan Barua.
lordship.
Is Vidhan Barua, there was a part here.
Yes,
no?
yes, lord.
Then you can strike out the name of Siddhartha Barua. You take instructions.
Lordship.
Heard with you, Luster, and it comes for the appellate. Whereas publication, and it comes to the appear for S1 number 2. Court of 3 Luster, and it comes to this for, and it's granted 2 weeks time to seek instruction regarding the continuation of this appeal against the S1 number 1,
Lordship.
who appears to wrongly.
Lordship. Oblige.
Item 26, in 26, LC has been received for office not dated.
No, we cannot take up substantial matters where even there is interim order needs to be extended. Others, he'll be paid.